Court of Appeals, Division 1 is now in session.
Thank you. Be seated. Good morning. Are we still? Yeah, we're still morning, aren't we? Now's the time set for oral argument in cause number 1CA-CV17-0357. And I hope I get this right, but Wayne S. Goshkarian versus Thomas P. McGovern et al. For your information, these proceedings are being both audio and video recorded, so in a couple weeks they'll be up on YouTube and you can just enjoy them to your heart's content. Counsel, each side will be entitled to 20 minutes. We would ask that you respect that time. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know. We will try to avoid taking up all your time, but ultimately keeping that time is your responsibility. We've reviewed the briefs. We've conferenced the case this morning. We are well aware of the facts and issues attendant to the argument. We want you to know that so that you can structure your argument accordingly. Counsel, when you come to the podium, I would ask that each of you state your name and who you represent. And with that, appellant's counsel, if you would, sir.
Thank you, Your Honor. I'm Brad Owens, representing the Goshkarians in this appeal for purposes of this oral argument. May it please the court and counsel, Wayne and Melissa Goshkarian came here today seeking to correct an error by the trial court in granting summary judgment, despite the myriad factual issues and legal issues involved. The trial court dismissed their complaint by summary judgment against their former attorney, Mr. McGovern, and his law office. The alleged malpractice, as initially alleged, was supported by a statement of facts. Yes.
Before you get rolling, you're not on the briefing. You've signed in today, but you're not on the briefing.
Yes, a notice of limited formal appearance was filed last night, and I apologize for the lateness of that. Did
counsel get notice of that?
I do have a copy of it here.
Just want to make sure we get you on the papers.
No, I appreciate that. There was another attorney.
Have you given us notice of your mailing address and you're an Arizona attorney?
Yes, I am. Bar number 010405.
I will take it, since you can do that, I'll take your word for that at this point. And whatever you have filed does have the information necessary for us to be able to get back to you with whatever we decide.
Absolutely. It's on the pleadings. We did file the notice of appearance for purposes of oral argument and then a certificate of service.
And I didn't mean to beat you up with that. If
no,
you go ahead with your...
I actually kind of expected that coming in light of what happened here. Their previous attorney that was going to argue here today had an unexpected death in the family. So I was called at the last minute to step in with just a couple days' notice here. So I'm filling in for that. I am familiar with the case, and so we ended up filing that notice of limited appearance late last night.
Thank you. And I'm sorry if I took you off.
I appreciate that. I want the court to be aware of that. So what the Goshkarians have asserted here in this case is misleading statements made by their attorney who was supposed to advise them and counsel them on moving forward. And Mr. Govan represented them in a fee dispute involving a personal injury, wrongful death litigation. Their son Dylan passed away as a result of some drug reactions by his mother, and it affected him. And so they hired a number of attorneys that went and made a claim against the $500 million trust fund that was set up, and ultimately that case was settled for $2.2 million. Complication arose because at the time the PI or litigation attorneys knew that there was a bankruptcy that had not been closed, and the Goshkarians filed that in 2003 because of the overwhelming medical bills from Dylan's care. So when the litigation attorneys got a hold of this, they realized there was a bankruptcy involved and that might be an issue, but they ignored it. They didn't go to the bankruptcy court and get approval of their fee agreement. The trustee didn't approve it. They didn't get approved for the representation, but they went forward anyway. A settlement was struck, and then on the advice of Goshkarian's other counsel, Mr. Hebert, they went and reopened the bankruptcy so the proceeds could be administered through the bankruptcy. At that point in time, Mr. Hebert suggested that they hire an attorney to contest the contingent fee agreement. He said that it was inappropriate, it had not been approved. And it's a 40% contingent fee agreement. When you're dealing with a lot of money like that, it adds up pretty quickly on something that was basically a simple claim against a trust fund. Issues of causation had already been established at that time, and so what we're looking at is damages.
But nonetheless, your clients agreed to that in writing, correct?
They did agree to that. Yes, Your Honor. But at that time, they're not lawyers. They didn't understand the bankruptcy rules, did not understand what the requirements that the bankruptcy court would impose upon that. So when they went in and reopened their bankruptcy and administered, their attorney, Mr. Hebert, recommended that they contest that because it was void. And we've cited a number of case laws that say it is void. You can't do that. If you try to, you are subject to the court coming down and maybe denying all the fees or only allowing quantum meruit. So Mr. McGovern was hired by...
Just from my keeping this linear, how's that? The court. You just said that, keeping the court. Bankruptcy court or state court?
Bankruptcy court.
Thank you.
Okay, so the bankruptcy court, they could file contesting a motion to contest the fee agreement to set it aside because it was not approved. And there's, myriads of case law that support that. It adds a different perspective. It's not just a state law claim now. It goes into the bankruptcy court. So the bankruptcy court has its own rules in dealing with the contingent fee agreements. And so that was filed, and Mr. McGovern represented the Goshkarians in moving that matter forward. The fees they were claiming at the time was $673,000. Part of that $2.2 million went elsewhere and into the estate of the son. So the 40% that they were claiming, at least with respect to the $1.9 million that ended up in the bankruptcy court, was the $673,000. Mr. McGovern hired an expert, Mark Harrison, who opined a 50-page opinion that the fee agreement was void under bankruptcy law. It's a fairly, direct and comprehensive opinion that, as a matter of law, it's void. And thus the litigation attorneys were limited to quantum meruit at best. So that's what Mr. McGovern was hired to do. And he later had, there were a couple of hearings, some status reports. For some strange reason, he wanted to keep his fee agreement secret, which, under the rules of the bankruptcy court, you can't keep attorney fee agreements secret. You have to disclose them. And so the court ordered...
So just so I understand this aspect of it, with regard to the challenge to the contingency fee agreement, that was not going to be paid out of the proceeds of the bankruptcy estate?
Yes, it was, assuming that the court approved it. You can't just do that. You have to seek court approval, something that they hadn't done.
Well, you still hadn't done it according to your narrative, I don't think, because you said they went in to set it aside, didn't they? Didn't you say when you started this that they went in asking that it be
To set aside the fee agement, yes,
So
because it was void. Yes.
But I'm trying to understand the array of forces here. So to the extent that the fee award would be reduced, it wouldn't necessarily go to Goshkarians, right?
Correct.
It might go to creditors in the bankruptcy.
Correct. I mean, that's what the bankruptcy court does. That's why it has the rule. It is straightforward. We're not aware of any exceptions to that. You have to have bankruptcy court approval. And the trustee has to agree to it, too, or be overridden by the court.
It's kind of an abstract dispute because your clients get the money if they win.
No, it's not abstract, Your Honor, because that's money that was paid out of the estate that could have gone to the Goshkarians because the creditors did not add up to $1.9 million. So they could have received more money from that once the creditors were paid and once the bankruptcy estate was administered.
I just want to ask one point of clarification. They went into the bankruptcy court and asked the court to set the 40% contingency aside, correct?
You're talking about the court in Texas with the litigation?
The bankruptcy court.
No, in bankruptcy court, they reopened it because it had been closed. So
they reopened the bankruptcy.
Reopened the bankruptcy court to get approval to administer the funds, and then the remainder would go to the Goshkarians. At that point, Mr. McGovern filed the motion to set aside the fee agreement or challenge the fee agreement.
He didn't request that the fee agreement be approved.
No,
He asked that it be set aside.
declared void because they didn't comply with the law.
But could they not have gone in and asked after the fact for the court to approve that 40% contingent fee?
The record doesn't reflect that. It doesn't reflect any,
And or that they did?
does not reflect that they did. And I don't know if you can retroactively go in and file a motion. They didn't do that here in this case. They just didn't do it. They didn't seek to say, we want to override bankruptcy law and we want our agreement declared valid. What they think they were trying, according to the record anyway, what they were trying to do was save it for the evidentiary hearing. There was a 3-hour evidentiary hearing. Forgive me. It was a long walk to the court this morning. And at that hearing, the litigation attorneys were going to try to argue that their agreement was valid in spite of everything that happened, but they were prepared to come in and argue some quantum merit, which was fine with the Goshkarians because a lot of these fees were referral fees. Not a lot of time was spent on the case because it was a trust fund that was set up already. Most of the exhibits were medical records from Dylan. So in going into that, the burden of proof for quantum merit is on the attorneys requesting the fee. And, you know, after Mr. Harrison delivered his opinion, would testify to that fee agreement would be set aside, and instead the court would look solely at the quantum merit. So that's what it was designed to go. That's where we were headed with this. When there was a hearing on June 7th, in which the court required Mr. McGovern to disclose his fee agreement. Well, this is standard bankruptcy law. It's nothing unusual with that. I don't know why he held it back. The record's not clear on that. But for whatever reason, he wanted to, and the court said, no, it's bankruptcy law. You got to disclose every fee agreement. So he did, but after that hearing, you have the emails, and there's two specific emails that we've referenced, and I want to reference here an oral argument. It's the June 7th email of 12:16 p.m. and 1:42 p.m. And in those two emails, Mr. McGovern makes some misleading statements to encourage and create a situation where the Goshkarians felt they had no choice but to accept a settlement offer of a reduction in the fees, and that they would settle for zero. Well, there's nothing that would reflect in the email that they agreed to settle for zero, meaning that there would be no discount. In fact, in the email of 12:16, Mr. McGovern states that we have a very big decision needed today. Okay, so this was after the hearing. So there's no authority at that time, even though he talked with them at that time, according to the email, he's asking them to come forward because there's a decision to be made.
There was a hearing a week from then, right?
Yeah, the hearing was 6 days from that, yes.
Not
It was
quite
set,
a week.
yeah, not quite a week, and it was a 3-hour hearing. Each side would have an hour and a half. And I'll address that as to the exhibits when I get to that part of my argument. But at that time, in these emails, there are several misleading statements, and one of them is that there was a zero settlement. There was never an agreement to do that. The Goshkarians disputed that. They did it in their statement of facts. They did it by declarations under Rule 80I. At the time it was Rule 80I, where you can make a statement under penalty of perjury, and it carries the weight of a sworn statement. For some reason, the trial court looked at that in its ruling and kind of discounted it and called it an unsworn declaration. Well, if it's made under penalty of perjury, it works, and it satisfies the requirement. So maybe the trial court didn't understand that, but kind of discounted all the Goshkarians' statements and disputed issues, which was error. So the 5 misleading statements that we have raised here on this appeal is the string of adverse rulings. Mr. McGovern claims that there was a string of adverse rulings over the past 4 months. There was not, and the trial court found 3. And of the 3, the first one was a hypothetical question asked by the court. That's Judge Haynes in the bankruptcy court, who said, assuming there's a valid fee agreement, tell me about fee splitting, tell me about quantum merit. okay, and how that's all going to work. So clearly that's a hypothetical question that was designed to elicit more briefing on the issue of fee splitting and quantum merit, because that was one of the issues. It's not an adverse ruling saying, I have decided that the fee agreement is valid. That's not an adverse ruling. It's simply a hypothetical question for the parties to provide more briefing on that issue. But in the trial court, they assert that the judge asserts that that's an adverse ruling. It was not. Trial court also references a box of documents. There was a box of documents delivered by the litigation attorneys to Mr. McGovern's office. He did not forward it to Mr. Harrison. He kept those, and for some reason that's an adverse ruling. It is not an adverse ruling. It's not a ruling from the court. It's just a box of documents, many of which were, the medical records or the things that the litigation attorneys were going to try to use to establish some kind of quantum merit claim. The third one the trial court goes to is the disclosure of the fee agreement, okay, which was not really an issue legally. He should have disclosed it. I don't know why he fought it, and the record isn't clear on that. But it's not surprising. So at worst, that issue is neutral. That's a neutral issue. So when Mr. McGovern states in the email there's a string of adverse rulings, that's false. It's not correct. But the Goshkarians hear that and they think, oh, we've got a problem here. We're going to have a problem. And that's one of the 5 that has been asserted here. There's also a litigation attorney seek $50,000 in fees. You don't get an award of fees in defense of attorney's fees claim in the bankruptcy court. You just don't get it.
Those circumstances.
If there's sanctions, no, you're right. If there's sanctions for an improper purpose.
Why wouldn't the bankruptcy court be applying state law, American rule? No, I mean, like.
No, state law covers state law. You need that as a foundation. But once you go into bankruptcy court, the bankruptcy court makes the rules and has the case law that says we're not going to allow fees on fee disputes. We're not going to allow attorney's fees.
They had an agreement.
Yes.
So it wouldn't arise out of contract? No, there's no 12-340-101 possibility?
That's a foundational claim. But when you go into bankruptcy court, that doesn't apply. The bankruptcy court says no, you can't. And the case is Baker Botts versus Asarco, 135 Supreme Court 2158. And that's in the context of fee dispute litigation, there's not an award of fees. You don't do that because the court didn't want to set up a scenario in the situation of bankruptcy trustees and creditors and debtors that there's a fee dispute there. So the bankruptcy court has overridden that by case law.
Wasn't there a later point where Mark Harrison said something to the effect that had he received the records that he apparently hadn't gotten, it may well have changed his position and he would have advocated for the 40%?
Yeah, as it relates to that quantum merit argument, I think the services rendered, he wasn't ready to go that far because there was some additional documents he'd received, but it doesn't change the underlying legal argument and the legal claim, which is that the fee agreements are not enforceable in the bankruptcy court and that the attorney's fees, there are no award of attorney's fees in a bankruptcy dispute.
So somebody would have put him on the stand to testify that he would support the 40% contingent fee, but it would be inadmissible because that's not allowable in the bankruptcy court?
No, he could go up and do it on that issue. Our point is that Mr. McGovern, as the attorney, should have come forward and advised the Goshkarians that the opposing counsel's claim for $50,000 in fees wasn't going to happen because bankruptcy law does not permit it. He did not so advise the Goshkarians, and he should have. And bankruptcy law is clear on that point. The bankruptcy court did not grant a additional request for 300 exhibits. That was done at the end of the hearing on June 7th when the litigation attorney said, 3 hours won't be enough, or our hour and a half won't be enough. We got, 300 exhibits. The court said, no, you're going to have to do it within the hour and a half time that's allotted to you. You're going to have to summarize the exhibits. That's a favorable ruling. It's not an adverse ruling. It's one that says, yeah, you're going to have to summarize and get it down, which the Goshkarians wouldn't have minded. If they prove up the services that were rendered under a quantum merit theory, it's going to be a lot less than the 40% contingency. Harrison's charge of an additional $50,000 in fees. You've got 6 days, 5 days to go to the hearing. The main reason why Mr. Harrison was retained is for the purpose of giving an opinion on the unenforceability of the fee agreement under bankruptcy law. That didn't change. That still was there. He was not retained for the quantum merit arguments that the litigation attorneys would had to have made.
But didn't he? Wasn't there a point at which he said he would? I'm just thinking about this generally. Wasn't there a point at which Mr. Harrison said that he might refuse to testify if he wasn't provided the documents and didn't have a chance to incorporate them into his understanding and his application of law?
Yeah, but it wasn't clear how that would change. He said, "I'll get back to you," in his deposition. He said, "I'll get back to you." So yeah, it might have affected his opinion, but not on the bankruptcy law issue, which is those fee agreements are void. And that was a biggie because it shifts the burden now to the litigation attorneys to prove up their fees.
So for all intents and purposes, Mark Harrison's testimony was absolutely without purpose, because he was just there to say that the 40% contingency might or might not be appropriate depending on what he had seen.
Was unenforceable under bankruptcy law. That's why he was needed in there to say that.
He also said he may reverse his decision had he seen these documents.
Under quantum merit, if somebody comes in and proves up their services, which they didn't do in this case, didn't need to because of the settlement, then you would go with that. And he couldn't opine on that because he wasn't hired to do that and he didn't review the documents for that. So no, he could not do that. Would it change his underlying opinion on the bankruptcy law? I don't think he said that. When I read the affidavit and some of the transcripts in there, that the bankruptcy law was contrary to what he had said before. He didn't do that. But once it's set aside, that shifts the burden all the way over. The additional boxes of documents, they were not needed. Most of the fees were referral fees. We would ask the court to reverse the granting of summary judgment. There are many factual issues here. If you look at the motions for summary judgment, they're massive with facts and statements, and we would ask the court to reverse that summary judgment and remand this for a trial. There's also two other issues raised in the briefs, but I am out of time. Thank you.
20 minutes went very fast, didn't it?
It did.
Wait. Hold on a second. Hold on. Counsel, we're going to put 2 minutes on the clock for rebuttal.
Oh, thank you very much.
One of the things we understood coming in was that this is going to be a very difficult case to address the issues, the totality of the issues in 20 minutes. So we have no problem. We'll give you the 2 minutes at the end.
Thank you very much. Sure.
Morning, Your Honors. May it please the court. Nice to see everyone this morning. I'm Scott Boehm, appellate counsel for the McGovern defendants. Trial counsel Mr. Woods is with me at the table. I've had hundreds of arguments in this court over the years, and until today, I've never been tempted to actually stand up and object. Most of what you just heard is baloney. There's no evidence to support.
In the legal sense?
In the legal sense, exactly.
Okay.
Let me start by addressing a couple of things. Judge Thompson, you asked the question whether this was kind of a theoretical issue about the assets. The answer is no.
I don't know anything about the.
No. Well, once, yeah, the settlement proceeds, even after the fees, were greatly in excess of the whatever creditors remained after all this time, because the bankruptcy was filed in 2003 and this is 2011. So there was a lot of dough left over, basically. Second, and this is what absolutely blows me away, Mr. McGovern wasn't hired to challenge the 40% fee agreement, and he didn't retain Mr. Harrison to challenge the 40% agreement. They were told there was no fee agreement, and this is all on the record. I mean, this is the summary judgment. Mr. McGovern's got. To say it's thorough is a gross understatement. Everything from the beginning of the case, all through the proceedings, what happened, all the emails, everything's in there. From the plaintiff's side, I'll get to the point that in a minute that the defendants have submitted nothing from a factual standpoint. Everything that Mr. Owens talked about that they submitted to the court is just not there. I mean, there's nothing there. As the trial court said in her ruling, you have no evidence. They made the allegations in the complaint, and that was it. They never submitted. At some point, this is of course the second time Mr. McGovern was sued for these. They first sued the bankruptcy lawyer, Mr. Hebert at Polsinelli, making basically the argument that they should never have reopened to come clean, essentially, with the bankruptcy court. That was filed by a guy named John Powers. He didn't have an expert, so after McGovern was joined to that case, after the Ninth Circuit dismissed the appeal trying to set aside the bankruptcy court's approval of the fee agreement, Mr. McGovern was added to the case against the bankruptcy lawyers. Well, you have to have an expert affidavit and expert testimony. That case was completely thrown out. So then this case is filed by Mr. Piper, same exact allegations against Mr. McGovern, but now the former lawyer, John Powers, is now the expert. Tom eventually, the defendants eventually filed a motion saying, you got to have an affidavit. You got the same problem here that you had in the other case. They didn't have any evidence to back it up. So Powers then becomes the expert. He submits a initial declaration, Exhibit X to, and it's also ROA independently, ROA 21, is contingent. He hasn't based it on any facts. He says, if what McGovern, based upon what the complaint alleges, if that's true, then that was a bad thing. They try to subpoena his file. The subpoena comes back. He doesn't have a file. He didn't review anything in coming up with this declaration. It's not signed. It's not an affidavit. There's no facts. He doesn't show up at his deposition. He doesn't file any disclosures. There's no disclosed opinions. There's absolutely no evidence that Mr. McGovern did anything wrong. It's the only thing they have is their complaint allegations, which were parroted again this morning. But most importantly, and this is where I started, Mr. McGovern and Mr. Harrison were told that there was no 40% fee agreement. And again, this is explained with detailed exhibits in the summary judgment, and again in the briefs, of course. They didn't know that the settlement would go to bankruptcy. They had no fee agreement with the Paxil lawyers. They didn't know about the split among the 6 Paxil lawyer firms. They never okayed 40%. That was not earned, and the Paxil lawyers essentially did nothing. So Mr. McGovern, he gets hired just a few days before the money's about to be paid out. Now keep in mind, the Paxil lawyers had filed everything under seal, including their fee agreements, all of the work that they did, the affidavits from Pat McGroder and Linda Sheely, supporting what was done, and and most importantly, the transcript from the Texas District Court, which is to the summary judgment pleadings, where Mr. Goshkarian gets up 3 months earlier, 3 months before McGovern gets hauled in. And Mr. Goshkarian tells the trial court in Texas, yeah, I know this is going to bankruptcy court. I know I signed the fee agreement. I approve everything, the 40%, the split, all on the record. McGovern doesn't know any of this stuff. So he walks in and tells the bankruptcy court, I'm here on behalf of the debtors to try to avoid the Paxil people from getting their 40% fee. And of course the bankruptcy lawyer, I don't know what he must have thought at the time, because everything that was filed by the Paxil lawyers to get their 40% was filed under seal. So the bankruptcy judge knew there were fee agreements, knew that everything had been approved, knew that the split had been approved, knew that they acknowledged it was going to become an asset of the bankruptcy estate, and he knew that there was a trial transcript 3 months earlier of Mr. Goshkarian personally standing up in it was done over the phone, but the transcript's there, to the bankruptcy court or the district court in Texas, saying, I'm okay with all this. So the settlement got approved. So the bankruptcy court, in reliance on Mr. McGovern's request, sets a hearing for eventually down the road, and then of course the bankruptcy or the Paxil lawyers hire Mike Carmel, who's a very well known bankruptcy guy here in town. And I think this is probably as good a time as any to, we're talking about Pat McGovern, Mike Carmel, Linda Shealy, Mark Harrison, Tom McGovern. Eventually, Grant gets called a liar too. All these well-respected, experienced, nationally known lawyers are being called liars and trying to get over on the Goshkarians based on absolutely no evidence. So after the trial court agrees to this evidentiary hearing, they hire Carmel, and Carmel starts sending them stuff. Tom finds out for the first time, and of course Mark does. Mark's April 4 affidavit that they're trumpeting so heavily was based on the idea. That's why he went to Quantum Merowit, because there's no, in Mark's thought, in Tom's thought, there is no fee agreement. There is no agreed upon split with these lawyers. It was never approved by anyone. Goshkarians had no idea it was going to bankruptcy court. Well, that's all baloney. Get back to my baloney argument. And they start realizing this when Carmel starts sending them the records and the transcript of the Texas hearing where Mr. Goshkarian started up. So on April 8th, 2 months before, June 7th, so almost 2 months before, Tom sends the Goshkarians a letter, email. It's in the record. All the emails are Exhibit F, one after another. And their theory of what they say, one of the reasons Tom submitted them, obviously, they have to be in the record. They don't say what they think they say, or what they suggest they say. So anyway, Tom starts getting all of this stuff in, and he sends him this April 8th email saying, the true circumstances are other than I was led to believe. It was a lot nicer email than I would have sent, frankly. And the barrage keeps coming. And that's when Mark says, I haven't seen what McGovern looked at. I haven't seen all the list of what stuff they were done. I haven't seen the trial transcript. You, Judge Jones, pointed out that you said something that Mark later backed off his opinion.
I think what I said was he said that he might refuse to testify.
He ran as fast as he could away from it, and at one point said that the Goshkarians and their current lawyers, who then tried to kind of bribe Mark into, I call it the bribe letter. It's Exhibit double H to the things. Tried after Mark gets full disclosure and says that he's not going to go along with this because it was all based on false information. They offer him $5,000 if he'll just kind of overlook that and stick with it. And that's when Mark said, and he repeated this at the deposition, that the plaintiffs are living in an alternative universe. That there's no consequence for the baloney that keeps coming out of their mouth.
So there's no viable expert opinion testimony then that's currently on the table by plaintiffs. I mean, at the time of summary judgment, was there Powers is off the table and Harrison is backtracking? Then then there's no other option at this point on the table.
Thank you. You're exactly right, and the trial court said that. I mean, even to the extent, and it's just, as I'm learning this file, I obviously got involved for the appeal. As I'm reading this, and Tom kind of told me about it, but as I'm reading it, in this case, Melissa Goshkarian, the ex-wife, they're divorced now, she shows up at her deposition and says, I never wanted to do this anyway. I never thought it should be reduced. They earned we agreed. We knew it was going to go into bankruptcy. She completely disagrees with what is stated in the complaint. And then the husband gets up there and at his deposition and essentially refuses to answer any questions, saying he needs to review his records again. Both of them say, now keep in mind, they've alleged that McGovern has lied to them. And they don't say misrepresented, negligent. They say he lied with an evil mind in these 5 emailed statements. Every one of which, and I'm already down to 7 minutes, so every one of which the trial court analyzed in detail and found to be absolutely true. They, for instance, and I'll digress here again, the Mark Harrison affidavit, the idea that McGovern lied to them and said Mark Harrison would have charged $50,000 to prepare for the hearing. Well, if you look at the actual email, he didn't say that. He said you'd have $50,000 in expenses, which would be McGovern and Mark Harrison. And of course, Mark's affidavit that he submitted later in support of this action, in support of the summary judgment for plaintiffs or for defendants, said, of course, that would have been the least I would need, because there are 3 boxes of thousands of pages of documents that were submitted under seal to the judge and that were considered by Pat McGroder and Linda Shealy that Mark had never seen. He says, I can't go in there and testify consistent with this April 4th affidavit when it was based on absolute baloney, and now I've got 3 boxes of stuff to look at. And then and so Mark's affidavit completely, it's true. That's why the judge found it was true, because Mark's affidavit says, yeah, I would have charged $50,000 for this because I was completely hoodwinked by our people.
Did did Mark Harrison say if things were as they were then being presented to him, because he hadn't had the chance to review the documents yet, that he would probably change his position and in fact say that the 40% was enforceable?
Yes.
He said it was enforceable.
He would have. It's in his affidavit. I've got it.
In what venue, counsel?
This was in the affidavit submitted here.
In what venue? Bankruptcy court?
No.
In state court? Where?
In this court. In this case. Because it went away in the bankruptcy court, obviously, because the case settled.
So what's left is state court issues?
Yes. It's all state court issues.
And he's saying the 40% was enforceable if things were as they were then being presented to him in the documents he had not received.
Yeah, but he had seen, by then he knew that they had stood up in Texas. He had seen the transcript because Tom had told him and said, look at this. And the fee agreements. Just keep in mind, he was on the impression that there were no fee agreements, that they had never signed the fee agreement, you probably have obviously had time to look at, but when you look at the fee agreements, they've got a very detailed split of who and how much each of the 6 law firms would be getting. Mark's affidavit, incidentally, is double F, exhibit double F. Judge Brown, I wanted to address something that you brought up earlier. Yeah, absolutely, this is a state law case, the state law issues. The lawyers were not in bankruptcy court as creditors or as trying to get fees in an adversary proceeding. They were trying to enforce a state contract. So, heck yeah, state law applies. The fee agreement specifically said that we get 40% and Arizona law applies. So the idea that Carmel, on behalf of himself and his lawyers and his experts, we're going to seek $50,000 in attorney's fees, was absolutely supported in the record. And Mark even covered that in his double F affidavit. So the facts are that Tom covered all that in the motion for summary judgment, and their response to the motion for summary judgment, and I smile because I'm just in disbelief over this. There are no facts everything in the response to the statement of facts, our statement of facts, is two declarations, one by Militia Goshkarian, not sworn, that just simply says.
It doesn't have to be sworn, does it? Under Rule 81.
Well, let's overlook that. At least hers is signed. The husband's isn't even signed. But there's no facts here. There's no anything. They just this is their facts in support of their response to the summary judgment, which is why the trial court said, you have no evidence. She kind of, if you look at, I don't know if you had a time to look at the court's ruling here, but she basically ruled in the McGovern's favor on four theories. She was right on every one. The first one was that the misrepresentation, they misrepresent and falsely paraphrase what the 5 emailed statements say. So, keeping in mind that their entire case is based on the allegations of their complaint, and they've never submitted any evidence on anything. The complaint misquotes, misrepresents what the allegations, what the emails say. So the judge said, they don't say what you said they'd say. Next, McGovern the trial court found that all of McGovern's 5 emailed statements were absolutely true. That the idea that they were false or misrepresentation is not only unsupported by any evidence by them, but if you look at the 50 exhibits and hundreds of separate paragraphs, if you actually look at the what was submitted to her, it's demonstrably, objectively true. So there were no lies. The allegations that there were lies turned out to be the lies, starting with the idea that there were no fee agreements. The third thing is that there's no evidence of any reliance by these folks, because the settlement was done, agreed to before any of these emails started. And then the first email that they're griping about confirmed that, hey, I just got off the phone with you guys and both of you agreed to settle. Now, their response to that is, yeah, I mean, every time they get caught in a lie, there were no, Harrison wouldn't have charged 50 grand. Mark says, yes, I would have. Then they quickly say, well, he didn't really need to look at that stuff. Well, his affidavit says he's not getting on the stand, as you say, unless he looks at it. Well, what expert's going to? But they have this never agreed to settle for zero thing. This case settled for 100 grand. They got $100,000. McGovern got them $100,000 discount 3 months after they stood up in a federal or in a district court in Texas and said, we agree to this, they get their 40%, and we know it's going to become an asset of the bankruptcy estate. So this didn't happen, but even if they said, we'll settle, but we're not taking zero, well, they got 100 grand. So I don't understand that whole argument. I'm trying to be creative. And finally, and ultimately, and I'm out of time, so maybe I'll take that 2 minutes that you were so gracious in offering. They've got no evidence. It's just amazing to me. This is almost like a case study in how not to try a lawsuit. They don't submit anything in response to our statement of facts, except referring back to the complaint. Well, you can't rest on someone files an MSJ on you. You can't say, well, I allege this in my complaint. Where's the beef here, folks? You got to come up with some evidence. And this is, they say we read it and it's all true. Well, first of all, it's not true, because what they allege in the complaint and what they say, it's Mr. Piper probably writing it, is inconsistent with what they testified. Well, under an appeal that I did back in the 80s, Wright versus Hills, you can't submit even a really bad affidavit that contradicts your deposition testimony. And we have Melissa Goshkarian on the record, and finish one thought first, Scott, saying that she never had any problem with 40% because they agreed to it. But more importantly on that is they don't have any expert witness. It's just absolutely absent in terms of evidentiary support. It's just baloney. Thank you.
Thank you, Your Honors. First of all, because the fee agreement had not been approved by the bankruptcy court, it was not valid in the bankruptcy court, and the court had authority to take a look at it and determine that, but that is a question of law. It is a pure question of law. No approval, no pre-approval by the bankruptcy court. There is no agreement that can be enforced in the bankruptcy court. So the Texas attorneys were in the bankruptcy court trying to argue for their fees, but their fee agreement had not been approved, so it did not exist according to bankruptcy law. That is the primary legal issue at play here, and that's what Mr. Harrison testified to. He did go on into other things that he said he would have to review that, but for the primary purposes of this appeal and for the case within the case, the fee agreement was not valid. It could not be enforced. Instead, the Texas attorneys would have to come in and argue for quantum meruit. Second, the Goshkarians did provide facts and specific facts in their statement of facts. And yes, the declaration of Wayne Goshkarian and Melissa Goshkarian are here. They're both signed. They were filed. And they say that the statements are true. And you've got 150-odd paragraphs in there disputing the defendant's statement of facts. So there's a myriad of factual issues here, all of which have been raised in the brief. The John Powers affidavit is a little unusual here. That's a preliminary expert opinion affidavit. It was filed, it was served. If at that time defendants thought it was inadequate, they should have raised it with the trial court and said, this preliminary affidavit won't work because of these reasons. They didn't do that. It's still there. It still provides expert witness testimony that confirms it. And, the case within the case is still the law, that bankruptcy law overrides and requires that such agreements be in writing. The issue regarding reliance is a little disturbing. This is a negligence case, a failure to meet the standard of care. And we believe the Goshkarians have shown that amply, and that there was no blanket authority to settle given to McGovern. We ask the court to reverse the granting of summary judgment. And there are the other two issues related to the defendant's statement of facts and the denial of the motion for partial summary judgment made by the Goshkarians earlier in this case, related solely to the legal issue on bankruptcy law. Thank you.
Counsel, thank you. A lot to be decided. We are going to take this matter under advisement at this time. We do thank you for your argument today, and we are adjourned.